I was expecting you to follow up with the Johnson-Morrill exchange, right? You give that a lot of play in the briefs. I won't take up time to explain what it is. You understand what I'm referencing. During the congressional debate, there was an exchange that you attribute some significance to, and some scholarly literature from Professor Lash questions that opposing counsel has. Can you respond to their criticism of your emphasis on that one exchange?
Certainly. Two things about that exchange, Your Honor. The first is that Reverdy Johnson took a quick look at the provision and said, why did you exclude the presidency? And I think the thrust of his question was, it would be absurd to exclude the presidency. And I think that's what everybody at the time was thinking, was of course we're going to cover the highest office. And the response by Senator Morrill was, well, it does include the presidency. Look at the phrase, any office under the United States. And then Reverdy Johnson agreed. And nobody came back later in the debate and said, well, actually, that language is somehow ambiguous.
And so one of the responses has been that that acquiescence may have just been out of collegiality, and, you know, why are we reading so much into one exchange that might have been nothing more than a nicety?
Well, I mean, certainly that's Trump's argument, but I think that if there were some intent to exclude the presidency from Section 3, given how important that would be, I mean, think about that. You'd be saying that a rebel who took up arms against the government couldn't be a county sheriff, but could be the president. That would be a really big thing. And you'd think we would see some indication in the history of somebody coming back and saying, no, we're carving this out because it's somehow different. And there's just no indication of that at all.
Right. I guess I just struggle with how much significance we should attribute to the McKee draft or the Johnson-Morrill exchange. These things seem to be sort of conveniently plucked.
There's always a question of how instructive legislative history is, and I think here, where the text is so clear, and where the consequences of saying that the presidency is not an office under the United States would be so bizarre, because you'd be saying that, for example, in Article 6, Congress can impose a religious test for no office except the presidency, and I guess you could require the president to be a Jehovah's Witness, or that no office under the United States, the holder of them can accept bribes from foreign kings or princes under the Emoluments Clause, but that because the presidency is not an office under the United States, the president can go to a foreign prince and ask them for a title of nobility. And that those results are just so counterintuitive to our constitutional structure that a careful parsing of legislative history here, I think, is interesting, but really not terribly necessary.
But if it was so important that the president be included, I come back to the question, why not spell it out? Why not include president and vice president the way you spell out, they spelled out senator or representative?
Well, I guess I go back to the kitchen sink approach, right? They used a really broad phrase, any office under, and then they wanted to include the handful of things that may not fall in that catch-all. I think everybody knew that the presidency was an office under. And along those lines, I just direct the court's attention to about, a dozen sources from speeches and newspapers that we've cited in our brief. Both supporters and opponents of Section 3 had no difficulty understanding this, including opponents. So Exhibit AD of our brief, we cite an example of a rather racist opponent of the 14th Amendment who was saying it was kind of deeply unfair in his mind that black Americans like Frederick Douglass could be president, but no person under a disability of Section 3 could. It wasn't just radical Republicans saying this. Everybody at the time knew Jefferson Davis couldn't be president and that any office included the presidency.
So to oversimplify, or perhaps oversimplify, your reading of Section 3 really is members of Congress who are not officers, electors who are not officers, and then all officers.
That's exactly right. That is our reading, Justice Gabriel. And I see that my 20 minutes has expired. Thank you.
All right. Mr. Olson, when you're ready.
Thank you very much, Mr. Chief Justice, and may it please the court. Trump levies two types of complaints against the finding below, but neither should disturb the district court's holding that Trump engaged in insurrection against the Constitution. First, he complains that the district court's finding that he engaged in insurrection was unsupported by the facts. But he ignores the worst facts that make clear the district court was correct to find that Trump gathered, summoned, and incited a violent mob that stopped the constitutional transfer of power on January 6th.
Mr. Olson, I'm going to stop you there because I think, was the district court in a position to make those findings? That is, did the district court have jurisdiction? Is a pretty fundamental question here.
Yes, the district court did have jurisdiction, and I can walk you through exactly how we get there. Article 2 of the Constitution gives states great latitude in how they select presidential candidates. Under that latitude, Colorado has enacted an election code that gives district courts, including specifically in presidential primary elections like we have here, the authority to conduct the qualification disputes like we had here. So yes, the district court had jurisdiction using the authority that the Constitution gives Colorado, and Colorado, unlike many other states, has chosen to implement that authority with this pre-election challenge under Section 11113, which Section 141204 incorporates specifically, which allows for electors, voters to challenge a wrongful act or about to commit a wrongful act by the secretary. And as testimony at the hearing from Ms. Hillary Rudy indicated, the way in which that plays out in Colorado under that statutory scheme is that the secretary makes initial determinations that are easily determined, and then following this court's decision in Kuhn and Frazier, additional evidence can be brought to bear in Section 11113 proceedings that allow for the qualification proceeding, the qualification dispute to be resolved.
So, if I'm understanding that argument, the state itself, or herself in this case, could not conduct an evaluation of the constitutional qualifications of someone to go on the ballot.
No, I would disagree with that. The testimony of the practice, which was consistent, is, and we have the Hassan case from a few years ago, where a presidential candidate said, I am not a natural-born citizen as that is currently defined. I therefore cannot sign the attestation that's required that says I meet all qualifications. In that circumstance, the secretary sent a letter and said it is my job to make sure that only qualified people are on the ballot in Hassan. Because you are constitutionally not qualified, you're not on the ballot. Hassan then sued, and then Judge Gorsuch on the 10th Circuit affirmed the secretary's authority and decision. Now that was under federal law, not the 1113 procedure.
And it was 2 paragraphs and not exactly a deep dive on our election code, wouldn't you agree?
I would agree, but the core principle was not in dispute and animates the way in which our election code works to basically allow for process to occur. So it isn't just the secretary making this decision of hard to find, but as this court recognized in Frazier, even simple questions like residency can be really hard to figure out sometimes and require a lot of evidence and
but that's still, I was going to say, here's my concern. The secretary's duties under the provisions that govern presidential primaries very clearly are limited to making sure that a presidential primary candidate is a bona fide candidate under party rules and has timely submitted a certificate of intent. That certificate of intent includes the Article 2 affirmative qualifications of age, residency, and citizenship. That's it. And in the Hassan case, as you pointed out, the candidate was unable to comply with that. So there's a very clear duty expressed in 1204.4, or 1 actually, saying that the secretary cannot certify such a candidate. Where is the duty here to examine other constitutional qualifications, or are you instead relying on the wrongful act language to support your petition under 113?
So let me point to 3 authorities that may help us resolve this question and your concern, Justice Marquez. The first is that Section 141201, which is the presidential primary part of the election code says that the purpose is, the intent of the people is to conform to the requirements of federal law.
Federal law governing the conducting of presidential primary elections.
I don't think it's so limited. I think it's more general. I think that it is federal law, which includes constitutional requirements. Second, I would point to 1412033, which says that presidential primary elections must be conducted in the same manner as any other primary election, which brings in 14501, which is sort of the general qualifications clause for state candidates, which certainly empowers courts to look at it.
Can I interrupt you right there? I believe your reliance on 501 actually undercuts your argument for a couple of reasons. One, the sort of boilerplate about election officials must conduct primary elections consistent with general elections. That is boilerplate that appears elsewhere in the code. And so I don't know that it has a whole lot of magic to it. It doesn't expressly incorporate it. And more importantly, 501 is limited to state offices. So how is that connected in any way to establishing constitutional qualifications for a presidential candidate?
So two ways, Your Honor. First is when, so section 14501 is in the state candidate section of the code. When the presidential primary section, which was passed recently, says presidential primaries sort of we do all these other primaries, our position is that that brings in the process of 14501, but doesn't include the limitation in 14501 because it would be silly to read that as only applying to state candidates. And the second is that Ms. Rudy's testimony at trial was that these qualifications, constitutional qualifications, aren't just the three checkboxes. That it says on the bottom of the form, attestation that you meet all qualifications. Section 3 is a qualification in the Constitution that someone must check that they meet. And if the Secretary certifies someone under that authority that doesn't meet all qualifications, that is a wrongful act. And that is a wrongful act that we challenge here in 113. I hope that addressed your question.
Mr. Olson, I want to hear, you never finished the start of your answer, and I'd like to hear all of it. You said there are 3 statutory provisions you're relying on. Could you please finish that answer?
Yes. So the third statutory provision is 1412032A, which talks about political parties putting a, quote, qualified candidate on the ballot. Now that section is directed to parties, but it requires that for a party to put a candidate on the ballot, it has to be a, quote, qualified candidate. And it is passing strange from our perspective to say that where the goal is to conform to the requirements of federal law, that we have a robust system to allow for challenges to candidate qualifications of all types, to exclude one particular qualification because it occurred in the Constitution, our most important document, rather than somewhere else.
So I'm just wondering if you can respond to the arguments made in part at the end of Professor Mueller's amicus brief, in which, for example, in looking at 1201, he talks about how the phrase governing presidential primary elections, as Justice Marcus just suggested, seems to modify both national political party rules and the requirement that Part